I've been doing this presentation for a number of years, so every year I try to have maybe a little bit of a theme, and maybe some of the things that I talk about fit into the theme. There's this research going around, you know, the Malcolm Gladwell book. To do anything well, you have to do it a lot. And today's question is, does that apply to antitrust? In other words, our courts may be seeing too few antitrust cases and therefore making mistakes when they do get an antitrust case. My sense is that other than the Second and the Third Circuits, I'm concerned that courts are just not getting enough antitrust experience. You have law clerks, too, that maybe haven't taken antitrust in law school. When I went to law school many years ago, I'm going to be going to my 35th reunion next month, antitrust was a very popular course. Actually, my class was taught by Robert Bork, so we called it Pro-Trust, but it was a popular class. This past spring, I taught sports and antitrust law combined at Drake, and I had 13 wonderful students, but I think most of them were there because of the sports angle. So I'm going to talk about the U.S. Supreme Court, some federal appellate cases, one decision of the Iowa Supreme Court, and antitrust enforcement activities. And try and get through all that in 45 minutes. I will give the NCAA a timeout this year. Usually, that's an annual installment in this presentation. But I'm just going to talk about a sports law case that's an antitrust case that's not an NCAA case. All right. The U.S. Supreme Court was supposed to have decided an antitrust case this past year, but unfortunately that didn't happen, and I'm going to talk about that a little bit. It was kind of maybe an embarrassing moment for the U.S. Supreme Court, and maybe kind of illustrates the theme that I just talked about. All right, the case was Visa versus Osborne. So we all have ATM cards, right? And as you know, mine is a nice Wells Fargo card, and it works really well at a Wells Fargo ATM. I don't get charged anything. But if I happen to go to somebody else's ATM, you get hit, and it's no different if you're a customer of another bank. I'm not meaning to pick on Wells Fargo. You get hit kind of coming and going, and that's why kicking the ATM there. You get a surcharge that is taken off the top by the visibly by the ATM operator, and then your own bank charges you generally a surcharge too. So it might be, say, $2 plus $3. That money actually, most of it goes to the ATM operator, whoever's ATM it is, minus a network fee. So you'll see on your card a different network identified. Mine says Visa, so I think it's in the Visa network, which is what this case is about. So anyway, Visa has, and MasterCard for their networks have an MFN provision. So, and that says if you want to be an ATM operator and play ball with us, then you cannot charge your customer more to use a Visa or MasterCard ATM card than you're charging anybody else, even though Visa and MasterCard remove a higher network services fee. So in other words, the net that the ATM operator gets is somewhat less. So that seems somewhat unfair. Some folks thought that was unfair, and so they sued under the Sherman Act under Section 1. And Visa and MasterCard, there's no claim they conspire with each other, but they both have member banks. And actually, although they're publicly held, these rules date back to before the date they were even publicly held. So the argument is that the member banks are conspiring to adopt this these MFN provisions. The district court initially dismissed the case on a 12b6 motion, but the Second Circuit reversed, and it said there was adequate pleading of an agreement in order to get past the motion to dismiss. The U.S. Supreme Court then granted Visa's request for certiorari. The defendants argued, and the argument, I'm still not entirely sure that I follow it, but generally what they're saying is mere membership in an association can't be enough to make you a conspirator, even if the association has a non-competitive rule by which all the members in the association agree. And the argument they were making seemed to have several different strands. I talked about this last year when I previewed the case. One is they had sort of a Twombly argument. Well, you have to allege enough detail to demonstrate that an antitrust conspiracy is plausible. You know, that's that special pleading rule that seems to apply to antitrust cases. And the defendants, Visa and the other Visa entities, argued there's no allegation that these banks are communicating with each other. It's just based on a trade association rule. And then they had some other arguments. When a joint venture acts as a joint venture and pursues the interests of the venture as a whole, that can't be the basis for a Section 1 claim. Or, and kind of a twist on that, a Section 1 complaint challenging a joint venture must plausibly suggest that the members were pursuing separate economic interests. If you think about it, 2 and 3 are kind of arguments that go to the merits. I mean, they sound kind of like arguments on whether the joint venture ought to be illegal or not the more basic question that really was what the district court and the Second Circuit were addressing, which is, do you have a concerted activity? Do you have an agreement sufficient for Section 1 purposes? Anyhow, so the U.S. Supreme Court took the case, as I talked about a year ago, and in October 2016, the United States filed a merits brief. Note, and this is, I think, one mistake the U.S. Supreme Court made, they didn't ask the views of the federal government before granting cert. I don't know what your sense is, General Miller, but that seems to me that is unusual in an antitrust case, that they would grant cert in a case involving 2 private parties before getting the views of the Solicitor General on the case. The government then, in its merits brief, essentially made the point that I've just made, which is, it seems like this is confusing. The defendants are confusing whether there's concerted activity or not, which is the only 12b6 threshold issue, with the issue you would get to down the road, which is whether the joint venture violates the antitrust laws. So the government also pointed out, as far as this concerted conduct issue, well, we have a case on that the Supreme Court decided just a few years ago. I'm an Arizona Cardinals fan, so that's why I picked Hassan Reddick. Anyway, and that's that American Needle case, which was the case where the NFL basically gave Reebok an exclusive to sell those hats. They retail for $34, by the way, to sell those caps like he's wearing. And American Needle, which used to be able to sell them, sued, claiming that this was an illegal boycott and a violation of Section 1. And the Supreme Court had said unanimously that no, that's enough for Section 1 purposes, because even though it's NFL properties, the members are all the different individual teams, and they're all individual decision makers, and that's enough for purposes of conspiracy. It's not a Copperweld type case. Of course, the U.S. Supreme Court in that case didn't weigh in on what the ultimate merits would be, and one can conceive of many defenses that the NFL might raise later on in the case, but it said it's sufficient if you have independent entities, even if they're operating through a single company for Section 1 purposes. So on November 17, 2016, and this is kind of what I think is the embarrassing moment for the U.S. Supreme Court, they dismissed the writ of certiorari as improvidently granted. So what happens is they get the government's brief, they then file they then receive on November 16th the reply brief of the defendants. November 17th, the case is dismissed. So they clearly had that outcome in mind, I think, before they got the reply brief. And the court said, well, basically the petitioners have kind of changed their argument. I'm not really sure I agree. I had those same 3 points up last year. I think they were making the same arguments when they asked the U.S. Supreme Court to take the case. You know, maybe the Supreme Court is just giving cover to the law clerk who wrote the cert pool memo. Regardless, you know, I do agree that the case didn't warrant the court's attention. And this is something that we're guilty of sometimes on our court. You just kind of get excited about taking a case, and then you look into it and you say, why did we take this case? And usually the justice on our court, who is nameless to the public but known among us, who kind of pushed the group of us to take it, kind of, you know, slinks back in their chair. Note also that the Supreme Court granted cert on June 28th, 2016. So this is kind of as you're heading out of town on your 3-month summer vacation type of situation. All right, let me talk about one question that I think may be of interest. Chantel, you talked earlier about Justice Gorsuch and class actions. Let me talk about antitrust cases. There is one antitrust case that I found that he wrote, one majority opinion he wrote on the 10th Circuit. And I think, I'm not sure I agree with it, and let me talk about it. It's a very, very concentrated Chicago school approach. I mean, maybe we could call it Hyde Park School or something like that. Too concentrated for my taste. All right, think back. General Miller, you were talking about Microsoft. Think back, you know, of those old days, you know, when Apple stock was down here and Microsoft was up here, and Microsoft was king. What originally would happen is when they would roll out a new version of Windows, they had people that were writing various kinds of various apps, just like today, that would then be able to work with the Windows operating system. And so they would give kind of advanced availability of their application programming interfaces, give those programmers a head start. So what happened is, after giving access during the beta version, when it finally got ready to roll out the product, and Bill Gates, who we will recall was sort of good at making statements that probably didn't play so well with an antitrust regulator or a jury deciding an antitrust case. Gates said, well, to give Microsoft a real advantage to our own software, we're going to deny access to the final version of the application programming interface. So it's kind of like you get them, you work with them all along, and then at the last minute you pull the rug out so they can't develop their products to work at that point with the Microsoft operating. Judgment is a matter of law. It was a trial, but it didn't get to the jury. Novell appealed. And it's really an exclusionary conduct case. And 10th Circuit said this is basically just a refusal to deal case. You're just not, you're refusing to make something available to a competitor. And they cited the law offices of Curtis v. Trinco case, which limits seriously the liability for refusals to deal. However, remember that there was an earlier case called Aspen Skiing, and this is the case where the U.S. Supreme Court upheld a plaintiff's verdict in a refusal to deal case. This was the one where the dominant ski operator in Aspen had been cooperating for years and years with this operator that had only one mountain. The dominant one had 3 mountains, and they would sell a combined lift ticket, and then Aspen, the dominant company, pulled the rug out, kind of like here, from the smaller one by discontinuing the arrangement. So the obvious question, as I was kind of paging through the opinion, is why is it Novell an Aspen Skiing type case? And the Trinco court said, in distinguishing Aspen Skiing, said, well, that's different because you were terminating a voluntary course of dealing, and that suggested a willingness to forsake short-term profits to achieve an anti-competitive end. Now, in his opinion, on the 10th Circuit, then Judge Gorsuch kind of juices up that holding, in my opinion. He says, as in Aspen, the monopolist's discontinuation of the pre-existing course of dealing must suggest a willingness to forsake short-term profits to achieve an anti-competitive end. That, in my mind, you see that subtle distinction there? It kind of changes the burden of proof a little. Trinco said, and I think Aspen Skiing said, that you can, from the termination of the voluntary course of dealing, infer a willingness to forsake short-term profits to achieve an anti-competitive end, which is the essence of exclusionary conduct. Judge Gorsuch says you have to have independent evidence on top of the discontinuation of the pre-existing course of dealing of a willingness to forsake short-term profits to achieve an anti-competitive end. And then he kind of analyzed the case to predatory pricing and said Novell had to present, just what I've talked about, evidence from which a reasonable jury could infer that Microsoft's discontinuation of this arrangement suggests a willingness to sacrifice short-term profits. So, as I've been saying, I think that's a little strong. As in Aspen Skiing, can't you infer what you need to infer just based on the fact that there was a discontinuation of what had been a formerly cooperative and presumably profitable and mutually satisfactory arrangement? And I think the analogy that's drawn with predatory pricing is also kind of interesting because, in my view, the U.S. Supreme Court has kind of put predatory pricing in its own box because predatory pricing is low prices, and low prices are almost always good for consumers. And so we want to be very careful and make there a high threshold of proof before you can sue somebody for predatory pricing. That's what the U.S. Supreme Court said in the Brook Group case. What Judge Gorsuch seems to do in this case is use the predatory pricing standard and apply it to this discontinuation of a voluntary arrangement, which I think that's maybe not the correct analysis and analogy there. So anyhow, maybe I'm reading way too much into one case, but I was interested in that. All right, let's talk about propane. Is anybody planning to grill tonight besides me? Beautiful day outside. Yeah. And you all know that terrible sinking feeling. The steak is on the grill. You've got a beer in your hands. all is good in the world, and then you see that dial kind of go as the temperature dial on the gas grill goes like that, as you're running out of propane, and you say, I say to my wife, Elizabeth, I think I need to run over and get a refill on the propane, and I just had 2 beers, so maybe you should go. Anyhow, if you've ever noticed, have you ever noticed that maybe it feels like sometimes those propane tanks don't last quite as long as they used to? Do you notice that at all? It's not your imagination, all right? This case is a class action. In 2008, when the price of propane rose a lot, remember there was this period where gas was like $5 a gallon or $4. I mean, it was, remember, we forget those days now, but there was that time. Anyhow, the allegation is the defendants acted in concert. The different distributors agreed among themselves, well, we'll just stop putting 17 pounds of propane in and we'll put 15 pounds in. And too bad for those people who like to grill and might not have quite as much propane as they used to have. Anyhow, there was a settlement in 2010, but the plaintiffs in this case alleged that the activity continued. You still had the 15 pounds of propane in the tank. There was a new complaint issued by the FTC. Class action was filed. The defendants moved to dismiss this lawsuit based on the 4-year statute of limitations in the Clayton Act. They said, well, the conspiracy occurred in 2008 when everybody allegedly agreed to act in concert to drop the amount of propane in the tank from 17 pounds to 15 pounds. So that was more than 4 years ago. And so the district court agreed with that and dismissed the case. The plaintiffs appealed, and 2 years ago, the Eighth Circuit panel affirmed the district court with Judge Benton dissenting. I talked about the case, and I said I thought that dismissal was maybe questionable, and once in a while I get something right, maybe not in my own cases, but in talking about somebody else's. And this year, the Eighth Circuit reversed en banc, and Judge Benton ended up writing the majority of the en banc for the en banc court. And so the issue is when you have an agreement to inflate prices outside the limitations period, but then the effects keep going and the same prices continuing to be charged inside the limitations period, can suit be filed? Is there a continuing violation? And I guess I wonder, think of the analogy, employment lawyers. This was a major controversy in employment laws. Anybody know what I'm talking about? The Lilly Ledbetter and all that, right? Where you have you have a discrimination against a disadvantaged employee as to wages that occurs outside the limitations period, but the effects keep on going. So it's kind of that same issue, and you'll remember Congress actually enacted legislation reversing what the U.S. Supreme Court had ruled in the Ledbetter case. So, majority of the Eighth Circuit says no, you can sue, but you can only sue for sales that occurred within the limitations period, which I think is a logical outcome. The new dissent says you have to allege the defendants engaged in a live, ongoing conspiracy sometime within the limitations period to survive a motion to dismiss. So, again, I kind of agree with the en banc majority in the Propane case. If you have a conspiracy, the conduct enabled by the conspiracy continues, then it seems to me maybe the burden shifts to the defendants to show some kind of break in the action, some period where there truly was competition and independent action as far as the fill levels of propane to avoid the continuing violation rule. Oh, excuse me. Oh, what did I do here? There we go. All right. United States versus American Express. This is, while the Eighth Circuit case might have been an example of, at least at the panel level, of the theme I'm making, that the courts are not perhaps seeing these issues frequently enough. I did say that I think the Second Circuit and the Third Circuit do a pretty good job generally in antitrust cases, and this is a Second Circuit case. So this involves American Express. American Express, as we all know, typically, I'll reach into my wallet again. I don't have an American Express card because there aren't as many merchants that accept it as Visa, MasterCard, right? So I've got a couple of, that's a MasterCard, I've got Visa, I've got, oh yeah, all kinds of good stuff in here. All kinds of receipts, Sam's Club, never mind. Anyhow, so typically Amex reimburses merchants less, but Amex, kind of like Visa in the other case, requires merchants to enter into non-discrimination provisions, and they forbid the merchant from doing anything to discourage customers from using Amex or charging differently for the use of Amex as opposed to other credit cards. So, for example, even though hypothetically Amex pays the merchant 1% less, the merchant can't make up for it by charging the consumer a 1% surcharge on an Amex card. So what happened is DOJ in a number of states, including Iowa, sued Amex, and the allegation was that these arrangements unreasonably restrained competition. After a trial, the district court found for the government and permanently enjoined Amex from enforcing the provisions. Amex appealed. So that, in terms of the structural facts, which I think are relevant to the case, the oversimplified facts are as follows. So you basically have 4 credit cards out there. I think we're familiar with their Visa, MasterCard, Amex, Discover, and it's pretty high barriers to entry. I mean, I don't think there's any likelihood that anybody new is going to come along and start a new credit card to compete with those big 4. Amex accounts for about 26% of credit card purchase volume, so about a quarter of it, which wouldn't seem like market power. However, the district court, and this was the government's theory, emphasized that cardholder insistence gave certain customers preference for Amex, gave Amex market power. And as said, the Second Circuit reversed. The appellate opinion is fairly complicated, but the gist of what the court said is this. Amex doesn't have market power. 26% is not market power. Basically, the credit cards all compete with each other, and it was not correct for the district court to say that cardholder insistence, in essence, kind of puts Amex in a separate market. The cardholder insistence results not from market power, but from benefits that Amex provides to the cardholder. You know, for example, I actually did used to have an Amex card that I got through my Fidelity brokerage, because I'm a Fidelity customer, and they would give 2% cash back on any purchases. When that relationship stopped, I canceled my Amex card, so I no longer have an Amex card. So, the gist of it is there is no market power. And one thing we should consider, I think, is sometimes we're inconsistent. Now, the theme in this case was the merchant should be able to charge a separate fee for use of Amex. Sometimes we don't like it when they charge a separate fee. Sometimes we want that. In cable TV, we want unbundled, and airline fees, we want it bundled. I think my view, and I think you would probably share this, General Miller, as long as if it's something that the customer almost always is going to buy, it ought to be included in the fee. If it's something that is truly an individual choice and it's clearly disclosed and it's a competitive marketplace so that there are different people offering different options, then let the marketplace determine it. One more twist, the government, federal government, now that there's a different administration, has decided not to ask for cert, and so the participating states, including Iowa, are carrying the ball to obtain review of the Second Circuit decision. All right, I said I would talk about one sports case. I will do so quickly. This is Sergio Miranda, and you have not heard of this particular baseball player. You probably even haven't even heard of the Stompers, because he is a minor league baseball player. And I just thought the case was kind of interesting. It's not legally significant, but it kind of illustrates sometimes the way the judicial and the legislative process works, and maybe a little bit of the underbelly of that process. All right, so all minor league ball players, I remember learning this for the first time from Michael Gardner. He explained the I-Cubs don't actually employ any of the players for the I-Clubs. Those are all employed by the Chicago Cubs give us our players, is what he says. They are all employed by a major league team. Allegedly, and this is what the lawsuit says, MLB requires that all first-year minor leaguers earn $1,100 a month, Class A $1,250, Class AA $1,500, Class AAA $2,150. So pretty low wages for minor league baseball players, allegedly collectively fixed by baseball. And minor league players don't belong to a union. So this is not like the major leagues or any other major sports league where there would probably be a labor exemption to an antitrust suit. So Sergio Miranda and some other minor leaguers sued baseball, brought a class action alleging a conspiracy in violation of Section 1. And the case was dismissed based on the baseball exemption, and the Ninth Circuit was affirmed. And I just want to talk about, there's sort of two ironies in the case. First of all, the Ninth Circuit, in the opinion, refers to the baseball exemption as the business of baseball exemption. And what's ironic about that? Anyone?
Well, in the case originally, they made the exemption, sometimes talked about being a sporting exemption.
Right, exactly. The whole basis for the exemption, it was, I think, Oliver Wendell Holmes or Brandeis, one of them, who said, no, it's like a lawyer's chautauqua. It's not trade or commerce. It's just an exhibition. They're just traveling the country having fun. It's not interstate commerce. So there is the basis for the exemption is that it's not a business, supposedly. The other thing I was wondering as I was reading the case, well, what about the Curt Flood Act? Because I know that Curt Flood died. He led the charge. Very courageous individual. Really sacrificed his very successful baseball career in order to bring about a complete change in the way the major leagues operate. And the way major league players are compensated. Well, anyhow, '98, after he died, Congress passed the Curt Flood Act, named his honor. I thought, well, doesn't the Curt Flood Act undo the exemption for concerted activity that affects ball players? And no, this is what I learned from the case. The Act partially repeals the baseball exemption, but it subjects only the conduct of concerted activity involving Major League Baseball players to the antitrust law. So what's ironic about that? Well, I'll give my answer. I mean, the last thing Curt Flood would have wanted to do was just help the Major League players who make millions of dollars, who have a union, and not help out the minor league players. But that's just, it kind of illustrates the way sometimes the sausage is made in the legislative process. All right, I said I would talk about our only antitrust case of the term. The court did not get to the merits, and Glenn, you know too much about this case, so you can. But it illustrated, I think, an important point about antitrust law maybe illustrated the theme of today's presentation. The case is Chiquin versus Wellmark. So you all know from the last presentation a lot more about Wellmark than I do, but you know, it's my general understanding. If Scott were here, he could correct me, but in most states there is a single Blue Cross Blue Shield health insurer, and in Iowa and South Dakota it's Wellmark. The names are actually sometimes somewhat repetitious. I think it used to be WellPoint in Wisconsin, and then it's Highmark in Pennsylvania, and then some of them just call themselves Blue Cross Blue Shield of whatever state. And then there's there's some mergers, and then Anthem is the biggest one, and that's, I guess, the one that came out of California. So anyhow, there's a multi-district litigation pending in the Northern District of Alabama involving suits brought by various healthcare providers, alleging that all these different Blue Cross Blue Shields are keeping out of each other's market. And allegedly this has monopsony effects because it allows Wellmark and each of the monopolists in their respective states to kind of drive down the reimbursement rates for healthcare providers generally. It so happens that one of the many MDL plaintiffs in Alabama is an Iowa chiropractor. So meanwhile, this is where we get to Mr. Norris's case. In the Polk County District Court, there's a class action case brought by Iowa chiropractors under the Iowa Competition Act, the counterpart to the federal antitrust laws that are involved in the MDL. And what happened is Wellmark persuaded the district court here, our Polk County District Court, it was actually, I think, in the business courts, to stay the Chiquin litigation in favor of the MDL, you know, until further order. And I guess, you know, that which could be a long time. It kind of reminds me of this when I was there was a kind of obnoxious sports call-in show that I used to listen to in Boston when I was growing up, and whenever they got kind of a young kid call in, because they don't really want children calling the show, they would tell the kid, "We're going to put you on hold till your voice changes." So until further order of this court. Anyhow, Chiquin appealed, and the Iowa Supreme Court, our court, reversed unanimously, and I think one of the points that we made in the opinion was that there's really a difference between the two cases. One of them is really an allegation that all healthcare providers are being affected by this conspiracy. That's the MDL, whereas the Iowa case really focuses on allegedly discriminatory treatment of chiropractors. So the court concluded it's unclear in our view whether any resolution of claims in the MDL would result in the resolution of claims in this action. And then, of course, in theory, an MDL is only for pretrial purposes. The cases would then go back to their respective federal districts to be tried. So, a couple of takeaways. Not all antitrust cases are identical. Antitrust maybe isn't too burdensome to litigate. Maybe one could say we decided we wanted our courts to get a little more of that practice that Malcolm Gladwell says is so important. All right, antitrust enforcement. Let me talk about that quickly. General Miller referred to these two cases. The federal government was successful in blocking the two major health insurer mergers over the last year, the Anthem one and the Aetna one. I'll try and talk about them very quickly. The Anthem case, I didn't realize you'd be staying for this presentation, General Miller. Say what? Not sure. But I mean, I do think there is a reason why you joined the case, because if it involves national accounts, they do business in Iowa, and that would affect the Iowa as well. I mean, they didn't specifically plead an Iowa market, but I do think that's correct. Anyhow, so this is a case about national accounts. So Anthem has 41% of the national accounts business. Cigna has 6% if they merge. That's 47%. So the Herfindahl, HHI indexes go up. That is what everybody looks at. Anthem's response to the case was, well, all right, you're right. There's more concentration, so there'll be some anti-competitive effects. We don't dispute that, but there will be two pro-competitive effects. One, with 47%, we'll have even more leverage to drive down the prices charged by Glenn Norris's clients and everyone else. And second, the merged company could offer the Cigna programs, which are innovative, to more customers. So the government, this is sort of using the government's argument against themselves. The government's complaint had featured what I would call the innovative competitor theory, that Cigna was this effective, even though it was a small player, even though it had only 6%, it was particularly innovative, and it was kind of bringing this innovation in the marketplace. And once you had the merger, the benefits of that innovation would be lost. It's kind of the same theory the government used to try to block the American Airlines US Airways merger a few years back, saying that US Airways was this innovative competitor. So that was the government's theory. As I've said in this presentation for a number of years, I'm skeptical of the innovative competitor theory. In my view, if the programs are good, they'll survive the merger. If they're bad, they won't. I view this as kind of a wash in antitrust theory, but that's anyhow. Anthem tried to turn the theory around and say, well, no, now yeah, you're right, they're innovative, and we'll start doing everything that they're going to do. Anyhow, the district court enjoined the merger. The DC Circuit majority affirmed. And I was bothered by a couple things in the majority opinion by the DC Circuit. One is that for anti-competitive effects, the court uses really this structural approach focusing on HSIs. That's okay. But then on the pro-competitive side, it uses more of an anecdotal approach. They really didn't have expert testimony that supported the anecdotal theory, in my view, on the pro-competitive side. Additionally, the DC Circuit majority in dicta questioned whether efficiency could even be a defense to a merger. In other words, whether you even look at the pro-competitive effects, and it cited some old 1960s U.S. Supreme Court precedent. Now, the dissent, written by Judge Cavanaugh of the DC Circuit, who's one of the many individuals that people have said should have been on the Trump list rather than me, quantifies both anti-competitive and pro-competitive effects. And so I think his approach is more consistent. He concludes the merger would have enabled the merged company to charge more, but it would have also reduced what they pay providers. So on a net basis, employers would save money. Now, that's not necessarily a good thing antitrust-wise, and Judge Cavanaugh will get to that. He also criticizes the majority's invocation of the 1960s merger cases, saying they're not good law anymore. Again, consistent with our theme. Two qualifiers, though, in the dissent. He would remand for consideration of anti-competitive monopsony effects. So even he wouldn't have the merger out of the woods. I mean, even if you'd followed his opinion, the merger probably was not going to go through anyway. And the other thing is, he doesn't buy the innovative provider as an argument for or against the merger. So the government thinks it's an argument against. Anthem thinks it's an argument for. In fact, he doesn't think Cigna is all that innovative. In fact, he cited some evidence in the record that actually Cigna customers utilize Anthem already has lower utilization rates than Cigna, which I guess is a fancy way of saying that all those innovative Cigna programs don't get customers to consume less health care. And I believe that the state of Iowa has maybe come somewhat to that conclusion, because my understanding is the new health care plan that we're going to have in effect starting January 1, no wellness program and none of that. They've decided that it's just not, it's actually not cost effective. So that's the only. Aetna Humana, I'll talk very briefly. I think this is a good, a sound decision. I think it's a good one. So this particular merger focused on two things: Medicare Advantage plans and Obama exchanges. That's where the reductions, in significant reductions in competition were alleged. Regarding one, unsurprisingly, Aetna and Humana are really the #1 and #2 in Medicare Advantage plans, and the court said that's going to be anti-competitive if you merge those. The real issue in the case was there was a proposed divestiture of approximately 290,000 Medicare Advantage plans to somebody called Molina. And the court goes through and explains why Molina was probably not going to be able to handle that business, and that was probably not going to work out. And then regarding two, the argument that Aetna made is, well, we're leaving the exchanges anyway, so you're not whatever you do with this merger is it's not going to be an anti-competitive effect because we're leaving anyway. And they had actually already pulled out of the 3 The court went through and agreed that Aetna was losing money in Georgia decisions, but it felt that the decision was motivated by the merger litigation, not an economic decision. All right. Last thing I'll talk about, I'm past my time, is Google, and this is the European Commissioner on Competition. I'm not going to try and pronounce her name because it's Danish. This is a case I truly don't understand it. I mean, I'm being a little bit flippant here. I really didn't understand the motivation behind Brexit until I read this case. $2.9 billion fine. Actually, it's actually there's a lot of precision. I wonder if it's maybe to some extent kind of misleading precision in the opinion. $2 billion 400 million, etc. euros. The explanation for the fine, I kept trying to look for some kind of an opinion or decision or economic analysis or anything like that. All I could get off the internet were 2 4-page documents that kind of were duplicative decisions, $725 million per page. I know people say our opinions are too long on our court, but this is too short. So Google abused its market dominance by giving Google Shopping a legal advantage. Google has given prominent placement to its own comparison shopping service. Rival comparison shopping services are subject to Google's generic search. Google has to respect the simple principle of equal treatment in search results. This is what they say. All bold fails is in the original, not me. So what's wrong? Number one, Google favors the Google product. I think most American consumers, at least, are savvy enough to realize that if you use somebody's search service, they're probably going to favor their own products in the search results. It's transparent. You still see the Google name. Number two, the search is free, so you have to monetize it some way. So you can monetize it by putting ads up, or you can monetize it in this way. Either way, it's going to give some kind of advantage. Either they're giving an advantage to themselves, or they're giving an advantage to the advertisers. The end result is not misleading. I'm not sure I care about it. It's not a tie, so this is not like Microsoft. Google is not making you buy one product, like its own browser, in order to get its own operating system. It's offering a product, searches, and what, again, if it's not misleading, why can't it tailor them as it wants? And the other thing is, Google isn't even the dominant player in comparison shopping. Amazon is, and this is a way to try to break into Amazon's advantage, and certainly everyone would agree that Amazon is one of the big boys in the tech world, just as certainly Google is. However, and this, I'll end with this point, note the hypocrisy of Google campaigning for net neutrality. They want your cable provider to be net neutral, but they don't practice search neutrality. So neutrality should, it's always a requirement for other companies, but not for your company. With that thought, I'll end. Thank you very much.